Holmes, founder of Homeowners for Justice, and your host today for Weekdays Live. And boy, do we have some more information. Always feels like it's groundbreaking information every day. More information is coming out. More media is talking about illegal foreclosure, so that's a huge plus. And I want to make sure that all of these links to these YouTube media presentations are linked so that every one of us can use them to spread them out to everyone we know. We must spread the word. And then guess who owns what? We've got some fairly disturbing information, and I'm going to just zip through it so that you'll have those links. I'm not going to play a whole lot about it, but the bottom line is we really do need to protect ourselves, and our guest today is really going to be talking about that exactly. There is no money, and this is something that we need to grasp and we need to understand, and so we'll welcome Joseph Jones to the show a little later today. But first, let's take a look at the media. What is going on? This is really exciting.
Bank of America, Chase, and other huge banks have stopped foreclosures due to potential problems with paperwork. Now, a South Florida law firm says it has hundreds of cases right here in Palm Beach County that prove some of those banks may have been committing a crime. News Channel 5's Mike Trim brings us this story you will see only on 5.
And this law firm calls them robo-signers, people who rushed faulty foreclosure paperwork through the court system. Now Florida's Attorney General is asking for a sit-down with several big-name bank presidents for an explanation. Within this tower of foreclosure depositions, the Ticton Law Group says it's found the groundwork of an illegal home foreclosure system.
It's massive, it's criminal, it's wrong, and it's proven with what lawyers tend to call a mountain of evidence.
That evidence, according to Peter Ticton, includes incorrect foreclosure paperwork pushed through by all types of banks. Ticton says banks hired unqualified workers to complete crucial foreclosure affidavits, the official document used for a foreclosure hearing. In many cases, Ticton says banks purposely put wrong income information on those affidavits to rush foreclosures through. This law group says by the time a homeowner got to the courtroom, they didn't stand a chance.
That the courts gave little credence to our position, and that we've made that repeated argument over and over again. Now the judges are starting to realize that it can be as big as this problem is.
And the problem is big, spanning from banks like Bank of America and J.P. Morgan Chase on down to Park National and Bayview Bank. On Tuesday, State Attorney General Bill McCollum sent letters to 5 big banks asking for a meeting and explanation. Out of the thousands of foreclosure lawsuits this law firm is handling, I'm told at least 500 originate right here in Palm Beach County. Now this law group is asking the state to look into its findings. Attorney General Bill McCollum says his office is joining other states in looking into the issue.
And we want these foreclosures to get these homes that are bad in terms of debt off the market. We need them to get off the market so that prices will bottom out on the general home market, and you begin to see those prices go back up again.
And this law group says banks could be found guilty of perjury if this is investigated properly. Now, the lawyers at Ticton admits bringing finalized foreclosures back in front of a judge could slow down the court system, but they say it could be a key part in restoring order in the state and nationwide housing market. We're live in the newsroom tonight. Mike Trim, WPTV News Channel 5.
So there we go. There's some more information. Now, I don't know about you, but I didn't really understand what that governor was saying, the attorney general, because it didn't really, let's get these homes off the market. So that didn't make a whole lot of sense to me. If you can figure that out, let me know. Now, what else I'd like to talk about today is breaking news. Some articles recently posted just a couple of days ago. The GAO slams poor planning by U.S. regulators of the $2 billion review of foreclosures. So the fact is, and these articles go on to state, which you can read, and that is, it was insiders that got the job to review them. And then they got paid. And none of that money flowed to homeowners. So the whole point was just a complete boondoggle, which, you know, is a natural and logical conclusion when you consider that the regulators think that their point, the point of them, the OCC, is to make sure the banks do okay. So if that's the point, we're not even thought about. That's what Sheila Barrett was telling us earlier this week when we listened to that interview. They don't consider the homeowners. We're just an incident. And that is true in many more ways than even just our foreclosures in our homes. Here's another quick article. Blame is abounding. Of course. The foreclosure review is flawed. Of course. And so now the GAO is addressing this. Of course. It's going to be a lot of talk about nothing. The homeowners have to rise up, and we have to do this ourselves. We already know this. That's why we're doing this. Now, who owns what? This is just a short little piece of this video, and it's talks about what they called, I thought it was a fabulous name, it's the MERS curse. And the MERS curse affects everybody. I've been saying that. You know that. We know that. Let's hear someone else say that.
Released his latest article the other day, and it's titled Accidentally Released and Incredibly Embarrassing. Documents show how Goldman et al. Engaged in naked short selling. This is all tied together, and at the top of the pyramid are corporations like JP Morgan and Goldman Sachs and Merrill Lynch who have been involved in this malfeasance and stealing homes from people. You told me yesterday when we talked briefly that there's a duality of the fraud going on here. It's title fraud and GAAP accounting fraud, and it's all tied in to people losing their homes. I'm going to let you run from there.
Well, first of all, Sean, I would like to stress to everybody, it's not just people that are in foreclosure or perhaps upside down underwater. It's not those people. It's everybody. This malaise, this fraud, this GAAP and title fraud affects 70 million homeowners, which is how many people that this MERS fraud has touched. So, it's just that it's discovered at foreclosure. That's when you figure out what happened. And here's what happens in a nutshell when you sit down to sign for a note for a purchase or a resale. Unknown to you, your note has already been securitized. Your signature is fulfilling a quota that needs to be filled because of the repo and the reverse repo markets, the demand that's there. The moment you sign, your note and deed of trust goes through a series of transactions regulated by the pooling and servicing agreements, all of which should be registered at the recorder's office at the county courthouse. But instead, they're registered in the name of MERS, which is a database, and they call themselves a nominee for all the members of the MERS system. Well, okay, so of course everybody's a member of a MERS system. I remember the first time I had to, there's 5,999, just one shy of 6,000 members of the MERS system when I actually last looked at the hard database. The MERS system took the Depository Trust Corporation as its role model when they developed this system. And if you really start to pick at MERS and what they are and what they do, they are literally a borscht. There's this black hole of ownership and title registration that's been totally privatized and can only be accessed by members of the guild. It's just like naked shorts.
Okay, so now let's talk about this because, my audience is familiar with the DTTC, right? Don't even get Bix Weir started on this or Andy Hoffman. It's a black hole for share settling at the end of the day. So when you buy and sell your shares on Wall Street and stocks, those settlements need to occur through the DTTC. They're essentially holding your shares in perpetuity. And as others like Jim Sinclair have said, get your shares back in your name so Wall Street can't continue to naked short sell them.
This is in your hands.
Yeah, and in your hands. Anyway, this is such a complex topic. Let's get back to MERS as it relates to this fraudulent activity going on. What can people do to get the title of their home back in their own names? Because it seems to me that these state attorney generals have made a deal with the devil, and they're letting Wall Street off here. Am I correct in that?
I would agree with that assessment, yes, pretty much, and especially now when you see that various state governments are already hijacking this settlement money that was supposed to be going to homeowners. Instead, they're using it for more government and to balance their books. So what can you do? Well, protect America's dream. The first thing you need to do is to find out if your home, if your life is infected by this MERS curse.
That's the first thing we need to do. Find out if you're infected by the MERS curse. Of course, We already know that virtually all the securitized loans are in MERS. And even if it's not found in MERS, let's never ever forget there's all these MERS lookalike databases. So maybe it's in one of them. Whether it's in MERS or not, remember it's in that type of an accounting scandal. And I wanted to just point out, and I've been showing you through that little video clip, that I do have the links to these presentations, these overheads that they had on that video. Here's the Mortgage Netherworld link. Here's the Securitization 11 Easy Steps. Here's the Federal Reserve, that's the owner of all the stocks traded. And I wanted to point out to you, if this is when owners are viewed as beneficiaries, not owners, and the stock is being held in a stock account and it's being cleared by the Federal Reserve, we can totally expect confiscation, just like they did in Cyprus. So that's what I wanted to share. I want to make sure that we understand how this really works, because unless we understand it, we can't protect ourselves. And if we understand that their policy in the bank world arena is to confiscate deposits, forced contributions to bank reserves, then it is not a big leap to say it would be understandable that if and when the government needs money, they will just go to the stocks and bonds. So if you've got an account, let's say you have $1 million there, you're feeling really good about yourself, you've got a lot of stock and bonds and everything is going fine, and then the government confiscates it. Just think about that. And I do believe that that would be a natural and logical conclusion of what we're seeing. Just a word to the wise. Now, I just want to show 3 set screens. This is from a guy who's really done a lot of research, and I will show you, I've linked the site where he pulls up his charts. It's about 59 minutes. It's about an hour. You can watch it yourself. But I wanted to pull these 3 summary slides out and point out to you what really struck me, besides all the facts, because he just goes through the stats and the facts. This is the truth as we can discover if you actually look at the numbers and forget what the media blats. And so this is one of the biggest things that struck me. For the first time in U.S. history, banks own a greater share of residential housing net worth in the United States than all the individual Americans put together. Think about that. The banks right now have on their books more housing net worth than you and I, than all of the Americans and all of the people put together. I'm telling you, they've been wanting to turn this into a renter nation. This is the information. We need to get this out to people. Then he goes on, he's talking about truly end times stuff. And another one, he talks about these are the conditions of the U.S. economy that mirror the economic situation prior to the Great Depression. Slow growth, massive deficits, high unemployment, foreclosures, and a shaky banking system. And he goes into other facts. The stock market's been dropping. Well, now it's rising. Now I do believe that this is going to be another stock market. It's a boom and bust cycle. It's a pump and dump scheme. They pump up the prices and then they'll snag all the money and stocks will fall. And the people always lose. I love what Jerry said on that little TV essay they put together. The system is rigged. The people always lose. The government and the powers that manipulate the government, in this case the banks, they always win. And we need to really pay attention to that. And then the last slide I just wanted to bring into the show is the differences. Not only are those items that we just talked about the same, similar to the Great Depression, but the differences now is that we have a structural, economic, and social problems now that we didn't have then, and massive obligations. So in 1929, we weren't 1.6 trillion in debt. We weren't facing 100 trillion in unfunded liabilities, which the math, just do the math. It's over 360,000 for you, for me, for everybody that listens to this, even if it's a baby, even if they can't understand it. You just take the number of Americans and you divide that into the debt, and this is what you're facing. And in 1929, most of our states were not bankrupt or insolvent. It almost hardly a day goes by that we don't hear of some other city facing insolvency, filing bankruptcy. Stockton just filed bankruptcy. And interestingly enough, Stockton wants to keep all of their pension contributions intact. And the debtors, you know, the investors that loaned Stockton the money to make their pension obligation payments, they're looking at like 17 cents on the dollar. They're looking at getting just ruined. So what's the judge going to do? This is a classic case, because if the pension obligations are not reduced and have to take a haircut too, then basically it's over, because no one will loan any city any money for any reason. It's a natural and logical conclusion. I mean, you see how this is going. And so, like he points out, I wanted to point out, in 1929, we did not have 21 million government employees with bloated salaries, obscene pensions, free health care for life. And today, 1 out of every 5 federal employees earn over $100,000 a year. And of course, in 1929, there was not Social Security, we did not have Medicare, and we didn't have Medicaid. And so the federal government had no such obligations. So we're really facing the cliff, and we need to not be afraid of that as much as be aware of that, so that we can protect ourselves. Get your stocks and bonds in your own name. There's a thought. Move the money out of the mega banks. You know, the mattress is looking better by the minute. So put your cash in the mattress. And then I just wanted to show, for the record, here is the economic research website that it's from the Federal Reserve Bank of St. Louis. And this is where he got his information and the other charts. And I will have that as a link also on the website under the comment section on this live stream, so that you'll have at your fingertips all of these tools that you can share and that you can use and that we can use to help ourselves protect ourselves. And so today I've invited Joseph Jones on the show, because he's got some discussions. He calls it the rules of the game. And so let's invite him to the show. Hi, Joseph. This is CJ. You're on the air.
Hello, CJ.
How are you doing?
Everyone. Good. Excellent.
Why don't you?
Day here in sunny California.
Why don't you tell us a little bit about yourself, what you're doing, and then we'll move into the rules of the game.
Okay. I guess I'm not an attorney or anything like that. I'm just an individual who happened to come up on some information about the judicial system, how it operates. I've had a lot of in-court experience in foreclosure defense, a lot. I was on the news a couple of times in Georgia. I guess, and I teach, and that's what I come to the conclusion after going through so much and trying to help people and defend their homes, helping people with criminal cases and so forth. What I do right now is I teach. I share information. I have a radio show. It is on Blog Talk. It's blogtalk.com/high frequency. We discuss a lot of different topics, ranging from criminal cases all the way into foreclosure defense and so forth. But I guess the underlying theme of everything that I do is help people essentially deal with debt situations.
Okay.
That's what I'm doing right now. pretty much.
And so you've told me that here's the rules of the game that I'm going to show on the screen right now. There is no money, public and private do not mix, stay in honor at all cost, and do not participate in public controversies. So why don't you explain to us what those things mean? We'd appreciate it.
Okay, well, the first rule of the game, because it is a game, I put up on my, I have a picture of how the Monopoly money and real money matches up, and the game Monopoly came out it came out before that, but Parker Brothers got it, I think, about 1936. And there's a lot of similarities between the game of Monopoly and what's happening in our society today. Also, I sent you a link to the usdebtclock.org.
Oh, okay.
Yes, usdebtclock.org. People want to go to that website and just look at it and stare at it. There is the problem. There's the source of all of your problems.
Right.
That you tend to not pay attention to. You get on television, they'll say, we're $16 trillion in debt, and then you turn the channel and just start watching the game. But you don't pay any attention to that.
Oh my goodness!
You get a traffic ticket, a mortgage foreclosure, a criminal case. Believe it or not, this is the source of everything that is happening to us. When I say there isn't any money, what I mean is there's no constitutionally mandated money.
Right.
The Constitution dictates what money is, and that's gold and silver. And of course, that was rescinded in 1933 with the New Deal with Franklin Delano Roosevelt. And ever since that time, we've been operating off of a debt-based currency.
And of course,
and that is securitized. It has to be supported with some sort of security, and that's created a whole plethora of problems that we are now dealing with, starting with the pledge of not only all the property, and notice I said property, not land, all the property in the United States of America, as well as the citizens in the United States of America. So if there isn't any constitutionally mandated money, then what is serving as a value for money now is labor. And, that's why people pay income taxes and so forth. But that is the number one rule of the game, is there isn't any money. Now, the number two rule, and let me go back, and that's the Federal Reserve notes that you're looking at, that's not money. that's not money.
Right. Right.
Let me go to number two rule real quick. Public and private do not mix. I think this is a very, very big problem in society, especially in dealing with foreclosure defense and just people in general. They do not understand that everything in our society has a public and a private side, and that all law breaks down to either public or private. All law is either public or private. You would be wise to get a Black's Law dictionary and look up the definition of public and private. Public law is essentially constitutional law, criminal law, administrative law, and international law. And private law is contract law, tort law, status law, and property law. And you need to know on which side of the fence you are operating, because they do not mix. You cannot mix them. You either have to be 100% private or you have to be 100% public. You're either all right or you're not right at all. And this is, if people would pay attention, because a lot of people think they're public, and they don't understand that the public only deals with government employees. And because of people's lack of understanding of this distinction, they get confused and they think a lot of laws apply to them that don't. Like, for instance, executive orders. Executive orders do not apply to you if you do not work for the government. But it does apply to you if you are a U.S. citizen, and people need to understand what U.S. citizen means. A very good movie to watch that will give a little clarity on that is the new movie Lincoln that came out a little while ago. You'll see a scene in there where General Grant is speaking to some of the delegates from the South, and he made a statement saying, well, that gentleman can say whatever he wants. He's private. Well, we're dealing with the public. We're dealing with the President of the United States. That's the public side. Private citizens can do whatever they want. But if you're on the public side, you can't. And so even something as simple as someone saying, I have constitutional rights, is an indication that you do not understand the difference between public and private. You do not have constitutional rights. You have constitutionally protected rights. The Constitution is a limitation on governmental power. It restrains the public. It has nothing to do with private citizens. And then the next rule was staying in honor at all costs, which is very, very important, especially when it comes to foreclosure defense. Most people's problems in dealing with these foreclosures is they neglected to respond to correspondence from attorneys. They neglected to answer ads in newspapers. They neglected to address their rights and assert their rights, and being proactive and not reactive in that. One of the remedies that is available to everyone in the United States is set off, and very few people understand that. But when you assert these claims and defenses in a timely manner, you are honorable, and you have to do it in a proper manner. The last rule is do not participate in public controversy. I like to say do not participate in public plays, because a lot of individuals also, this is a big problem, especially what I see in foreclosure defense. People are approaching the court system as if these are Article III courts and that their rights are supposed to be recognized, and these are not Article III courts. These are Article I legislative tribunals. These are territorial courts that you're going into. I like how Gene Keaton said it. He said they're private trading companies, and that's exactly what they are. They're private. They are not public courts, and people want to ignore that fact, and when they enter into these courts, they do not, they haven't even taken the time to demand the nature or find out what jurisdiction they're operating under, and so they don't know the true rules that the court is operating under, and they go in and they lose because they don't understand that they're there to adjudicate contracts. It doesn't have anything about doing rights or anything like that. And your exhibits need to be lined up in a row. You need to have accomplished an administrative process. The country is in bankruptcy. It is being administrated by a foreign entity, and these judges, when they enforce a statute, they are acting ministerially, not judicially, which means that they're taking Article III judges and putting them in Article I courts. And if you look up the definition of Article I court, it will tell you that it is a court that is not subject to the requirements or restraints of a, Article III court. You can just look these words up and you can see this for yourself. And read Article I, Section 8, Clause 9 of the U.S. Constitution, and you will see that the legislature has the right to constitute tribunals that are inferior to the Supreme Court. The legislature, they regulate commerce, and these are commercial courts that you are going into, and you need to know the rules of commerce. I hope I said that as succinctly as possible.
Okay, I'm completely overwhelmed. You're of course, you understand this, and obviously this is the first time that a lot of us have probably heard this. We so appreciate what you're sharing. So I want to step back a bit. You said a couple of things that I at least want to address, and then I want to move into what should we be doing. But you said private and public do not mix, and then you listed a bunch of the difference. Can you say that list again? And then I would like you to talk about what you meant by set off. I heard that in passing. So those are the two things I'd like to talk about first.
Public and private, I guess some examples of public and private. If the court system has a public and a private side, I'm sure people have heard of the word in camera. In camera proceeding is private. Look it up. You will know you're in an in-camera proceeding in court is when the judge just walks in and no one says, all rise, court is in session. If that is not being done, you are in chambers. You are in an in-camera proceeding. You're in the private chambers of the judge. A lot of people don't recognize that. You have public and private schools. You have public and private corporations. Like when a corporation corporation is not private anymore, that they were going public. You have Bill Gates is the richest man in the world publicly because he's publicly traded. There are people on the planet who have a lot more wealth than Bill Gates privately. These are private individuals. It's in everything. When you get on the plane, you are going on public transportation. If you've ever had the privilege of flying privately, you will see you don't go through any of that stuff that people go through when they ride on a commercial airline.
Right.
I go. My friend has a plane. We go to the airstrip. We park right next to the plane. Jump on. Go where we want. Land. Jump out. It's a difference.
Tell us again about the court systems or those laws that you said when you first ran down the public and private in the legal sense. Refresh our memory on that.
Okay, I'm not sure exactly what you're asking, but are you saying when you're talking about when a judge enforces statutes?
Well, you mentioned, I can't even express myself well enough to tell you what I want you to repeat.
Well, let me say it like this. You have Article 1 courts.
Okay.
You have Article 3 courts. Article 3 courts are courts of law. Article 1 courts are courts of contract. We no longer have, we have probably one, the Court of International Trade in New York is an Article 3 court. We do have Article 3 judges, but we do not have any more Article 1 or Article 3 courts. If you check the Supreme Court looks at standing status, case, or controversy before they take on a case. 99% of Americans have contracted to be U.S. citizens, meaning that you have given up the republic and you've gone into a democracy. You have given up your God-given rights for benefits and privileges, for civil rights. So in that case, now the country is in bankruptcy. So when the country went in bankruptcy, there is a foreign power who is acting through the Federal Reserve, because the Federal Reserve is not a governmental entity, all right? And they have pledged everything in the country to these people, which is why we have all these administrative agencies. They're administrating the bankruptcy for this foreign power. Now, the court system they are utilizing now is an Article 1 court in a colorable admiralty jurisdiction that deals with contracts. Now, how do you approach this court? You approach this court by doing an administrative process. You always have to approach. That's why everything in the court is procedural. All of you are losing on procedures. That's what you're losing on. That's what the attorney does against you. He does a procedure. When they get ready to foreclose, they go hire an attorney, someone who's an expert in procedure, and they send you a notice, a dunning letter, so you have 30 days to respond. You don't respond, now they hold you in default, and then they run an ad in the paper for 4 weeks. You don't respond to that. Then they do a demand for the premises. You don't respond to that. And then they take all these exhibits and file a unlawful detainer against you if you're in a non-judicial state. If you're in a judicial state, they file a lawsuit against you. And then they take you home. And then they come into the courtroom with all these exhibits. They're supposed to, at least. There's a procedure they're required to follow. And many of you try to fight them by challenging that procedure, saying that either they were insufficient in some manner, maybe there's a securitization issue and they don't have standing to come into the court, or the documents are not legitimate. And all those work, those work to some degree. But you would be much more effective if you took a proactive stance and followed the 4 rules. Number one, you identify the fact, first of all, there isn't any money. So you have a right to set off the debt. And setting off a debt means that when you have mutual obligations that occur in the same transaction, it's a different transaction with a set-off. You can set it off very easy. Like if someone says I owe them $500, and then I invite them to my home, and they come in my home and knock over my lamp, and it's $500. I can say, well, let's set that debt off. I owed you $500. Now you knocked over my lamp. Now you owe me $500. They balance each other out. Let's just zero it out.
Right.
That's an easy example of a set-off. Well, what's happening with the public and the private, you have a right to set off debt as well. Under Title 12, 1811 L1, a promissory note is the same as cash. It lets you know that this promissory note is a cash proceed. Also, when you look up the definition of financial institution, you will see, and you can Google that, I don't have it memorized off the top of my head, but you will see that a closing table is considered a financial institution. So you are making a deposit in a bank when you close. Now, if anybody studies GAAP, you will see that they are all required to follow generally accepted accounting principles, and they ledger this promissory note as a asset and a liability simultaneously. Right. Double entry bookkeeping is what they call it.
Right.
And they have your promissory note listed as an asset, and they have it listed as a liability. Well, what they do is they do a derecognition of that asset off of that balance sheet, and they have to fill out an FR 2046 balance sheet that tracks that. They have to report that to the Federal Reserve. But I don't want to get too off base. You can set off a balance sheet. You can demand a set off of a balance sheet. That's one way of doing it. Or you can tender them a negotiable instrument for a set off. It is not a payment. Stay away from the word pay. You're not paying anything. That's what they try to trip you up when you get into court by saying, hey, what did you pay? Where did the funds come from? You know, all this type of stuff, you know, they like to bring up in court. They call what they call vapor money theory. You'll see a lot of them talking about that. But you are setting off the debt. You're not paying for anything because there is no money to pay for anything with. If you want to test this, I went and bought a car, and while I was buying the car, I asked the banker, where are you getting the money that you're about to loan me for this car? And no one can answer the question. They start off by saying, oh, it's coming out of the depositor's account. No, that's against the law. And are you telling me that if I put $100,000 in your bank, you're going to go out the back door and loan it to someone who may not pay it back? No, that's not it. Well, it's coming out of reserves. No, you can't loan your reserves either. That's against the law as well.
Exactly.
Well, here, just sign this right here and get out. They just want you to sign the paperwork and get out. They're not going to tell you where the money's coming from. And that's lack of full disclosure. But back to what I was saying as far as with set-off, when you tender an instrument that is constructed properly according to the Uniform Commercial Code in Article 3, and then and specifically you're doing an accord and satisfaction under 3-611, I think it's 611. It's called an accord and satisfaction. If you read that carefully, it tells you about set-off or discharge of debt, and it also tells you how they can bring the debt back if you pay attention to it real closely. And that needs to be sent to them properly. And, you know, and I usually do a qualified written request or verification of debt request, and I do a number of different things. And I get them into default, and then I do a bill in equity. And I seek a declaratory judgment against them. Because now you are approaching equity with clean hands. You can demonstrate through your exhibits that you have attempted to resolve this dispute administratively before it ever got to court. You have all your exhibits in order, and and now you can go into an equitable proceeding with clean hands and ask for a declaratory judgment.
So have you actually been able to get into a declaratory judgment position?
No, and nobody has. What they will do is, and this is the problem, this is why I'm looking for other remedies, because what they will do is they will take themselves off the case. They will, and you have to take them all the way up to the Supreme Court, because the judges will just recuse themselves. That's what they've been doing with me. They'll just take themselves, recuse themselves. The case just sits in limbo. You do writs of mandamus, and Now you begin to see that, okay, this is not a real court system that we're dealing with. No one wants to be the one to give you a ruling, but it lets you know that, hey, you did it right. Everything right.
Okay, so for limbo land, this works to get into limbo land, but it doesn't ever yet resolve it.
Yeah, it puts it in limbo. No, well, no, some people get I've heard people get resolutions and so forth. I'm not going to lie on here. These people are not going to do anything. This is, I've been doing this for a while. I don't see them doing anything publicly.
Right.
Put it like this, publicly, and we're on the public air, so read between the lines what I'm saying.
Exactly.
They're not going to do anything publicly that's going to allow a lot of individuals to get their homes free and clear. If that was the case, I'd be a very rich man. People would be lined up outside my door saying, hey, I hear you can get houses free and clear.
Exactly.
That's not going to happen. It's an individual thing. It really comes down to basically, do you know what you are doing? You will get experience. Things will begin to happen to you. You may get calls from agents, from the bank, people questioning you, the IRS, different things like that, and you'll begin to get the sense that, okay, we see that you're awake. Let's see, do you really know what you're doing? It's an individual thing. It's not a thing where somebody's going to put, okay, we're going to set up shop, and now I'm going to run all of this through. And I'm really skipping a lot of things as well. But what I'm giving people is something that they can go in court and fight with. I've had cases where I went in court in an unlawful detainer, and I did administrative process, and I told them, I said, I've already set off this obligation, and the judge held up my instrument. I had a copy of my instrument. He said, look, this is a worthless piece of paper, This is worthless. And I said, excuse me, but that's not for you to decide. That is for that attorney to take that to Saxon Mortgage Company,
right,
and they can return it to me with evidence from a defect from a qualified third party, and allow me an opportunity to cure such defect. Absent that, this is settled and closed. And he ruled in my favor because I was absolutely right. It doesn't matter. There isn't any money. Remember rule number one, don't let them trick you with, oh, this has no value. The only thing that has value is your labor. And if someone else is taking control of your labor, what they are calling you is a slave.
That's right. Wow,
That's
what
all
a
it
concept.
is. If you're telling me that you can draft instruments using my labor, but I can't, you are calling me a slave. And that is exactly what they're doing. Because when you look at those Federal Reserve notes, if you look at those serial numbers on there, they match up with the numbers that are on the back of your Social Security card. They have been privately pledging. It's called pledging. No different than when you take your car title up to Title Max and get some money for it. It's the same thing. It's a pledging of a security. They're pledging human resources and to pay, and we are paying that back in the form of income taxes. It's the same thing. So you're telling me that you can take my labor in the form of a birth certificate and pledge it, but I can't. They did give us a remedy in that set-off, but you have to only do it from the private side. You got to know how to operate privately, because on the private side, you are a creditor. On the public side, you are a debtor. So if you are conducting yourself as a public individual, you are devoid of having any commercial energy to do anything with. You have to do it, and I had to discover that as well. You have to come into these courts privately and take care of all this stuff, and administratively privately. You don't put things on the, I had to learn, that was trial and error with me too. You don't put a lot of things on the public record, and do all these things. You take care of these matters privately.
Oh my goodness. So okay, let's start at the beginning. We've gathered a little bit of information that we can understand. We've heard an awful lot of information that I'm sure a lot of the viewers, unless they've been following you, are probably as a little bit awash as I am. And so what do you recommend that people do first? How do we start?
I'll take you step by step. First step, when
Okay, let's take a person who has stopped making the loan payments. They don't have a notice of default yet, so I call that limbo land. And let's just take a deed of trust state like California, and then let's, if it's different, just point out how the mortgage states, the judicial states would differ. What should someone do?
I always tell people to do is either a qualified written request or a verification of debt request, because they're not going to be able to verify the debt. You know how they do. You do the qualified written request. They send you copies of your deed of trust and payments, and all they're really trying to say is that we have a contract with you because, look, your conduct has said that you have a contract. You've been making payments to us, even though they don't have the original promissory note anymore or anything like that. So the first thing I do is I do a qualified written request / verification of debt request.
Okay.
When I ask for a verification, what I want from them is an affidavit from someone who can bind the corporation, all right, meaning that can hold the whole company liable, and that's usually the CEO, CFO, the secretary, or someone like that. But I want an affidavit from them, and I'm going to send this to them, certified mail, with an affidavit of mailing. I use an affidavit of mailing because a notary is a witness. You always have to have two witnesses. That comes from the Bible. And your first witness is your notary, and your second witness is your certified mail receipt, because they have to sign for it. So I need some witnesses, all right? So I'm going to send this information to them, certified mail, and I'm going to have a notary. And the notaries in California are woefully ignorant.
Probably. I think they're ignorant everywhere.
They have the notaries in check in California because they do not understand what a financial institution is. They changed the law in California to trick everyone because everybody was doing this. The people who knew it, they said they're doing it to quit the abuse of what they call protest, because this is a notary protest is what I'm about to describe to you. So they said that, notaries cannot do notary protests unless you work for a financial institution. Okay, well, let me give this to all the notaries in California, because you need to, first of all, you need to educate yourself and stop being so afraid. Oh, we can't do that. They said we can't do that. We can't do that unless it's with a financial institution. Well, if you go to 31 U.S.C. 5312, 31 United States Code 5312, which is money and finance, it will give you the definition right there in number 2, financial institution, and they give you 26 different definitions. And everything from a private banker, credit union, thrift institution, currency exchange. I mean, just go through this list. Pawnbroker, travel agency, operator of credit card system, a telegraph company, the post office, casinos, all these things, automobile dealerships of financial institutions. Look up and find out what they mean by when you say financial institution.
Right.
So that you will understand what it is that you're doing. Because they cannot prevent you from doing a protest, because you are all private bankers. You're really a private banker, which is C on the list. So that's the number one thing. So I'm going to utilize a notary, and you're going to have to get a knowledgeable notary. I usually go and put my own through training. They can get a book called Pombinos, which is a national notary book. When they try to tell you, when you call down to the Secretary of State, and when they try to tell you, notaries cannot do protests, and it's a financial institution, I ask them, what do you mean by financial institution, and from where do you derive your definition? And they will not give you the answer. See, this is the deception that is going on with your government.
Right.
They don't want to tell you things.
Yes.
You have to call these people and ask these people questions and stop presuming and assuming that you know what they're talking about. You think you know what the word financial institution means. You don't know. You think you know what type of court you're going into. You don't know, because you haven't gone and asked on the record. So the first thing I would do is I would ask them for a payoff too. After I did a verification of debt, I would ask them for a payoff. The reason I'm going to ask them for a payoff is because I'm going to do an accord and satisfaction with these people. Now, what is an accord and satisfaction? Well, everybody may be familiar with UCC 3-603, was it 603B, which is tender, I think it's 603B, 3-603 UCC. I'm typing it up on my computer.
Oh, okay.
And you got 3603. Yeah, that's 360. That's tender payment, and you got UCC 3-611. 611 is a very important one to study because it's talking about an accord and satisfaction. Is it 611? Oh, wait a minute, maybe 311. Hold on. Yeah, UCC 3, I'm sorry, it's UCC 3-311, accord and satisfaction by use of an instrument. So what I'm doing right now is I'm staying in honor. I'm abiding by rule number 3 on my rules. I'm being honorable. There isn't any money for me to pay for anything. The United States is in bankruptcy. The New Deal, which is House Joint Resolution 192, June 5th, 1933, codified in Title 31, 5118D2, which is the rescission of the gold clause. Implicitly, the United States government has an obligation to the American people to pay all of our debts because they took all the money away.
Right.
It was against the Constitution, unless they're going to be in violation of the Constitution. So we have a right to set off a debt. Now, if anybody wants to challenge me on this, there is an individual, his name is Vernon H.C. Wright. Vernon H.C. Wright. He is the chairman of the Securitization Forum. He is one of the individuals who was originally responsible for the creation of a lot of this securitization. But in 2004, after the Enron debacle, the Financial Accounting Standards Board, which is the entity that is responsible for promulgating GAAP, which is generally accepted accounting principles that all federally insured institutions must abide by, they wanted to give more transparency to investors. So they wanted the banks to give full disclosure to everyone about their rights of set-off. And the banks did not want to do it. They did not want to do it, but the reason that they wanted to give full disclosures is because they wanted to put in all of these contracts a way for you to waive your right of set-off. Because when they securitize these instruments, they do not put the promissory note in the trust. They transfer all rights, title, and interest to the promissory note inside of the trust. However, for it to constitute what is called a true sale, they have to be in possession of enough of the rights. And you can look at it like a bundle of sticks approach. If I have 100 sticks, I give you 90. And I still have 10 of the sticks. Do you have enough sticks to say that you truly own everything? Well, the argument is no, because you as the obligor or the original borrower or alleged debtor still retain some rights, and those rights are the right of set-off. And if you Google set-off, isolation, you will see all 52 of these letters that came across all around the nation in 2004. They're still present on the internet. They don't think that you will be able to read them and understand them, so you should grab you a good financial dictionary as well as a law dictionary and read it very carefully and closely, and you will see what they're saying. They're essentially saying that the American people will not discover that they have the right of set-off because they're too stupid.
This is just
essentially what they're saying.
This is just amazing. So back to the recommendation. The first thing you do is a qualified written request and a debt validation.
Or a debt verification. There's a difference in a qualified written request and a verification of debt request.
Okay, can you...
Qualified written request, they'll just send you documents. A verification of debt request is much more effective, because if someone says that you owe them money, they have to swear to it, because the only thing that matters in court is sworn testimony. There is no debt in the United States. There's only a presumption of debt, and honor and dishonor. And in the United States, default constitutes payment. That's why they're always trying to get you into a default judgment. If they can get you in a default, they can say you owe. They don't have to prove anything. That's what's going on. The whole game across the board is getting you into a default judgment, because there isn't any money. Go back to rule number 1. There's no money.
Right.
Everything is promissory notes. You look at the Federal Reserve notes; those are promissory notes. There's no money. There's no money. They're offering up bonds to pay. There is no money.
That is just that. What you're saying is just so different from everything, and this is why it's so important that we pay attention. What do you recommend we do to get more information about this?
Well, there is a document I have you can read. You need to start reading certain documents. There's one in particular that I always recommend to everybody. It's called Creditors and Their Bonds. You can get it off the internet. You can Google it. It is entitled, "It Only Hurts When I Laugh." Put a comma in, Creditors and Their Bonds. And you'll see this document come up, and you should read that entire document, because it tells you how to do an administrative process, and it explains some very occult type things that the average person may not be aware of in their judicial system. So that is the first thing I always tell people to do, is educate themselves. A next thing I would tell people to read is a document on the internet called "What is Acceptance for Value?" And reason why is because in that document he gives you a very good explanation of set off and how you set off debts from the private into the public. It is a technical read, but it is a very good read if people want to get an understanding of what is going on with the court system. So I would educate myself first. I definitely would get me a Black's Law Dictionary. Another thing, let me tell everybody, stop appearing pro se. Stop appearing pro se. You cannot challenge jurisdiction in a pro se status. You have to challenge jurisdiction in the proper person, the proper persona. Get you a Black's Law 4th edition, because they're going to hide these definitions. Look up impropriety persona, and you will see the challenges to the jurisdiction have to be made, and your proper person.
So now we need who? If people can't appear pro se, then does that mean they need an attorney? Can someone else appear for them?
You cannot use an attorney. If you use an attorney, you admit to jurisdiction. Having an attorney automatically admits jurisdiction. You're challenging jurisdiction. What you're saying, because none of these courts have jurisdiction, because they're Article I territorial courts that are only conducive to corporations, corporate fictions. When you're challenging jurisdiction, you have this thing called in personam jurisdiction and in rem jurisdiction. All of these actions in court are in rem in nature. It means against a thing, not a real living soul. Which is your straw, and people have probably heard about this straw man thing, which is nothing more than a franchise. But when you're challenging jurisdiction, when you come into the court, you're not there to answer any questions. You're not going to answer any interrogatories or anything. You have to make a special appearance, and you have to do it in your proper person, right? And you have to make a record of this, and you're there to address one topic only. Because for that court to have jurisdiction, they have to have two parties with standing, two real parties in interest with standing. And what would demonstrate that they have standing is they have to have proper documents. And coming in with copies of documents does not give them standing. That is slight evidence. All right? That's all that is, and it's subject to challenge. And you do not need to admit to anything. Is that your signature? No, that looks like a very good forgery. Do you have the original for my inspection? When was the last time you made a payment? Well, sir, do you mean I haven't made any payments? I've been inveigled and tricked out of my money. My money's been stolen from me. You know, something like that. You know, you need to be creative with your responses. Also, you need to learn how to answer questions with questions, because they are operating off of a presumption and assumption, and these are rebuttable presumptions. You need to ask questions to get clarification. Because the judge, as soon as you challenge jurisdiction, that judge is now attempting to obtain jurisdiction by asking you certain questions. Right. Immediately. He's doing it so fast that you don't even recognize it. Right. Well, I'm challenging the jurisdiction of this court. Well, sir, isn't this your name on, isn't this your signature on this contract? Well, yeah, it's my signature, Your Honor, but they don't have the original promissory note. You just lost.
Yes.
You just tell anything you say can and will be used against you. So, you know, those are just examples. You got to challenge everything from the gate, from when it jumps off. But you should be challenging everything. You should, when they put an ad in the paper, write them a letter, certify with an affidavit of mailing. I saw you run an ad in my paper that is my property that you're attempting to steal. Whoever this is, you need to demonstrate that you have proper documentation that allows you to do what you're attempting to do right now. The attorney, when he sends you a dunning letter, I need to see a contract that you have with this bank that shows that you have some type of agreement. Because who is this guy sending you a letter? You don't know who he is? He just popped out of the blue, sent you a letter, said, I'm working for Bank of America. You need to, you know, who are you? Do you have a bar card number? Are you insured? Are you bonded? You have a contract? Find out some information. Attack the attorney. And you need to have a record that you did all of this. So when it does go into one of these territorial courts, you can make a record and say, hey, look, you know, Exhibit A, Your Honor, I attempted to contact him on blah, blah, blah. They failed to respond. Here's an affidavit of non-response from a notary, and as well as here are the certified mail receipts demonstrating that I mailed it on X, Y, and Z day. The post office said that they did receive this at 10:02 a.m. on such and such date, and they failed to respond. Here's my Exhibit 2, Your Honor, and you know, and then you make it a record. And you can never go into the court without a court reporter. If you go into the court without a court reporter, you lose. You lose. They're gonna run over you. You can't ever go into a court without a court. You got to make a record. How are you gonna appeal and you don't have a record? I don't understand that. But back to the administrative process. When I asked for the payoff, then I tendered them a negotiable instrument or something for a set-off. There are many different things that you can use, but it's a set-off is what I'm doing. And right there with UCC 3, in California, it'd be California Civil Code 3611. But it's the same code in all 50 states. That's why I use the UCC, because no matter what state I go to, it's the same codes.
Right.
After that, I would give them 10 days to respond. Okay, the 10 days comes from the rule of 72, because 72 hours constitutes a contract. They got 3 days they got 3 days mailing time, 3 days after they receive it to decide what they're going to do with it, 3 days to send it back, and 1 day for Sunday. If they don't respond within that 10 days, I give them an opportunity to cure their default. I send them another dunning letter saying, hey, look, on X, Y, and Z date, I sent you this. You didn't respond. I also send that by a notary. I have a witness to everything I'm doing. I let another 10 days expire. After that, I have the notary issue a certificate. Now, a notary certificate is a legal document. You will need to study in your particular state, look up notary certificates. In Georgia, they make it very clear. Georgia has some very good laws in Georgia for notaries and identifying notary certificates. But it would be wise if you went to a law library and got an American jurisprudence and studied notaries, because then you will find in there that it will tell you that a notary certificate can only be controverted by a jury trial. A judge cannot kick out a notary certificate, especially if it's been properly introduced into evidence. And make sure your notaries keep a notarial record book, because if they want to challenge you, they may call that notary in and ask for her records. They default out do a bill in equity and seek a declaratory judgment. If you have all your exhibits, just think about this. Have tendered these people an instrument, whether it be an EFT, promissory, or whatever you use, GSA forms or whatever, and they did not respond. There is a rule that says silence is acquiescence in law. That is a maxim of law. It doesn't even have to be codified. That's a maxim of law that says silence is acquiescence. Now, individual only has to respond to you if they have a duty to respond to you. These people have a duty to respond to you because they are asserting that you have a contractual obligation to them. Now, the reason I ask for the payoff, because when you read Accord and Satisfaction, it outlines in there that you have to send all of this information, how they direct you to send it. So you send the information the way they want to, you default them out. Now, when you ask for a declaratory judgment, you can say, okay, Your Honor, Exhibit A, I sent them this notice. Here it is. Here's an original affidavit of mailing from a notary. Here is my certified mail receipt that goes along with it, certified from the post office. They did not respond to this. Here is my second exhibit where I gave them an opportunity to cure. Here I have an original wet blue ink affidavit of mailing from the notary demonstrating that I did mail this off. Here's a certified mail receipt from the post office showing that I did mail this off, and they did not respond to this. Here's my last exhibit, Exhibit C. This is a certificate of non-response, original wet blue ink from the notary, certifying and affirming that they did not respond to any of my correspondence. Now, Your Honor, I want a declaratory judgment, on these people to show that what are my rights in this particular matter. This is an equity proceeding. It has nothing to do with statutes, codes, or common law. It is what is right. Equity is fairness, impartiality, and even-handed dealing. This judge is supposed to give you, because he's acting in a ministerial capacity, and he's supposed to give you a judgment on that. And that's why they run, because they know they're supposed to give you a judgment on it because you did everything correctly. A lot of times what they'll try to do is they'll try to remove it to federal court and then try to change it from a declaratory judgment into some type of petition to set aside foreclosure or something. I mean, these people are incredible. I've seen them do all type of things. Like, what are you doing? I'm not seeking a petition to set aside foreclosure. This is a declaratory judgment. What are you talking about? And you will start to see everything I'm talking about. I'm putting this out here so people will know what's going on. Because most people I see, they don't know what's going on.
Exactly. I totally agree. And now from your discussion today, I feel like I don't know what's going on. And I thought I did. This is just,
it's
this
all
is
about,
outstanding.
Well, what it is at a base, it's all about slavery. I mean, you have you have people on Wall Street who are receiving payments, and you got people on the other side of the wall who are making payments.
Right. Yep.
All right, and the people who make payments are slaves to the people who receive the payments. You got creditors and debtors. But what it is it really breaks down to knowledge, because the people who think they're debtors are really not debtors because there ain't any money. You have to be tricked into thinking that you owe some money. There's not supposed to be one homeless person in the United States of America. This is the greatest country on the face of the planet. It is just that the have in their apathy, in their pursuit of pleasure, in their lack of respect for higher education, have allowed in here and usurp our authority and replace it with somebody else's authority and make us their slaves.
So
all this happened.
How do we fight back? I mean, obviously we've been talking about individuals and losing their homes, trying to fight back to keep them, and doing it in a manner that at least they could keep the house, even if for now they can't get complete resolution. But nevertheless, that's a win in my book, for example. But really, what you're talking about with, if there is no money, I mean, what should we do as a people? How can we proceed? What should we be doing? What should we be thinking about or planning on or getting a vision in our heads with?
Well, the first thing, educate yourself. Stop. change your thinking. I think that people have allowed television to influence their perception of reality too much. You should just get rid of it. I don't even watch television. I stopped watching television probably about 7 years ago. And it really has changed, helped me see things a lot clearer. But that's the first thing, is educate yourself. Know your rights. I remember a sheriff told me one time, he said, you're always talking about the Constitution. Bet you haven't even read the Constitution. And he was right.
Whoops.
I had not read the Constitution. So I had to, and that's how I found out this information. I said, you know what, I don't want anybody ever to say that about me again. Let me pick up and read the Constitution. Yeah. Let me understand what Article 1, Article 2, and Article 3 means. What this checks and balances means. It is the biggest indication that the American people are ignorant when you hear on television discussions about taking gun rights. That is an impossibility. The government has no power to take anyone's gun rights, because gun rights were put there to protect you against the government. They're private rights. But because everyone's status is on the public side, they can make any rule or regulation they want to and dictate to you if you are a public entity. And people do not understand what that means. If you look up the word public figure in a Black's Law Dictionary, under the second sense, it will tell you it's someone who voluntarily participates in a public controversy. So once you become a public figure, now you come under their authority. Once they always ask you, you get this driver's license, are you a U.S. citizen? Passport, are you a U.S. citizen? At the border, are you a U.S. citizen? I mean, they're always constantly trying to get you to say you're a U.S. citizen. And a U.S. citizen is a 14th Amendment citizen under the Lieber Code of Lincoln. When the North and the South battled, this is what's happening, y'all. When the North and the South lost, the North is militarily occupying, well, the U.S. government is, Washington, D.C. is militarily occupying the rest of the country. That's why they have districts. Just no different than when they occupied Germany, South Korea, Japan, same thing. Iraq, when they take over a country, they put a base there. They're doing the same thing in the United States. The courts that you're going into are nothing but military courts that are sub-corporations of this federal court. That's why the district courts are there. They are debt collectors. They are collecting on the debt. It's called a war contribution. Look up the word war contribution. They shorten it to contribution. They are collecting debt, a war debt, from the rest of the country, and they taking y'all houses, they taking y'all cars, they taking your children, and they taking your liberty. And how you're going to stop it is that you're going to have to, first of all, wake up and understand the difference between a U.S. citizen and an American citizen. If you don't believe me, get you a Constitution and look up every time you see the word citizen before the 14th Amendment, it is with a capital C. Every time you see the word citizen after the 14th Amendment, it is with a small c. They use the rules of English grammar to deceive you. That is a proper noun and a common noun. A proper noun is a particular person, place, or thing. A common noun can be anything. After the 14th Amendment, they made corporations citizens. They're called persons. They gave corporations rights and duties. So before the 14th Amendment, they were talking about someone in particular, American citizens. After that, they're talking about anything. You need to get back to the capital C, not the small c. Right now, everybody's operating as a small citizen, the small letter C citizen. You got to get your status back to the capital letter C. Now you have standing. A lot of times, the U.S. Supreme Court, they kick out cases because the first thing they do is look at your status and your standing. How are you going to come in here and claim rights and you don't have rights? You're a U.S. citizen. as American citizens? U.S. citizens are subject to the authority of the United States, which is 10 miles square in Washington, D.C. The United States ain't the entire country. These are the several states. California is its own country. That's why they got a constitution. So is Texas. So is Florida. You got to understand the difference between this. And then identify yourself as a private individual or a public individual. Private people have more power than public people. Public people are public servants. They serve, the public serves the private. But you have to identify yourself as a private individual. I have a citation of authority right here. It tells you, I got this out of Black's Law Dictionary. It tells you real clearly. It says, when acting to enforce a statute and its subsequent amendments to the present date, the judge of the municipal court is acting as an administrative officer and not in a judicial capacity. Courts in administering or enforcing statutes do not act judicially, but merely ministerially. And that's Thompson versus Smith, 154 SC 583. And what that's saying is that the judges do not have any judicial power. They're just following, the agencies are coming in, bringing people into these courts. They've already done an administrative process, and all they want the judge to do is give a declaratory judgment. That's it. You need to be doing the same thing.
You know, Joseph, that makes such sense to me. Even though it's the first time I've really heard it, it really rings true. We so appreciate your sharing today, and trust me, I'm going to be in contact with you. We need to continue this conversation. If you're willing to work with us, I'd really appreciate it. The people need to hear what you're saying, and we need everybody in the country to really understand this. Wake up and understand it. And truly, until we know that this is how it works, how can we know? So we need to have that expressed to us. Like I said, this is the first time I've really heard this, and you came upon a recommendation of one of our listeners, one of our viewers, and I just so appreciate everyone in the country that's following us right now, sharing with everyone else these kinds of powerful knowledge and understandings and links, because together, this is what it takes. I mean, you know all this, but unless everybody understands, or a significant number of people can grasp this, and we can move forward as a group, what difference does it really make? We're all lost. That's my summation.
I mean, that's why I started doing my radio show, because people, they really don't know the extent of tyranny that's going on in the country. These people are very, very good at hiding what they're doing.
Yes.
And
I agree.
You have to know some law to see it. You have to have knowledge. That's what it is. They can put something right in front of your face, and you won't see it unless you have the proper information to be able to, decrypt what you're looking at. And that's what I'm trying. I really ran through things real quick. It's a really short time in an hour to do something. But hopefully the books that I've given everybody, definitely check out the American Securitization Forum. Study those letters that were written to the Financial Accounting Standards Boards regarding Statement 140. It's FASB 140. Know what an FR 2046 balance sheet is. Understand what an S3A registration statement is, and how, when they try to say they lost the promissory note. And know what a B424 prospectus is. Know those things. Those are good things fundamentally to know. But also you need to know what a set-off is and how to do an administrative process. If I leave anybody with anything, that's what I will leave you with that. Understand, it is vitally important for people to understand how to do an administrative process, because they are following administrative law.
Right. Oh, Joseph, this is really great. And I'm smiling because you give us this long list of stuff. I've been making some notes on the screen to try to catch up with it. And I will be talking with you about, actually, let's break this information up, and let's have you back, and we can talk about these items, maybe even offer some webinars or something, so that people can follow along, listen and learn, because everyone's going every which way right now. And yet they can, if we can condense this information and get it out so that people have tools to work with, then that'll facilitate the waking up of the public.
Yes, it will, and I understand. I want to thank you for having me on your show. I appreciate it. I do have as I said earlier, I do have I did a blog talk on administrative process. If people want to just go to my your listeners, if they want to just check out my archives, I talk about all this in detail. A lot of it in detail. And that's at blogtalkradio.com/high frequency. You can just go into my my archives. I touch on a lot of these subjects, and I do seminars too as well. But I'd be more than happy to to do something with you, because people need to know this information. They need to get an understanding of the procedures.
Right.
the being proactive and stop being reactive. You have power. You have all the power.
Exactly.
All the power. They have no power. The only power they have is deception.
At which they've done very, very well.
Very well. Deception and fear.
Yes. Yes. And misunderstanding. It's always about the words, isn't it? They change the meaning of the words or the capital or lowercase letters that make a difference. And most of the people in this country are completely unaware of that. I know that for a fact.
Yes, they are. David Wynn Miller, I'm gonna give him a plug too. I'm looking at his stuff right now. He's on YouTube. You can check him out. He has this. His thing is the mathematical interface of language, and I just find it very intriguing because he's saying that there is a way to communicate where it will be true. He said, but a lot of what they're using in their language is it's not. You can interpretate it in many different ways. Like if I say 2 + 2 is 4.
Right.
Yeah. Right now in your mind, you're making a presumption that I'm giving you a mathematical equation, but I could be saying 2O + 2O = FOR. You know what I'm saying? So
very good example.
So it's like, you're presuming something because it's called an item sonen in law. That is the word item sonen. You look that word up in a law dictionary, it means same sounding. But it's very, very interesting. They use the language. People, if you come in those courts and you haven't taken some time to study language, they're going to get you. And they're going to be right in what they're doing. And you're going to be hollering, talking about, oh, they're crooks. And no, they're not crooks. It's not their fault. You didn't study.
And on that note, we're going to have to stop the show today. We could go on and on. I'm sure you could talk for hours. And this has been utterly fascinating. I really appreciate you coming on the show and sharing this stuff with us. And I really look forward, on behalf of all the country, in getting this information out to everyone. Thank you so much again, Joseph, for sharing with us. We do appreciate it.
Okay, thank you. And thank you for having me on. Y'all have a good day.
You too. You too. And with that, guys, we're going to have to say goodbye, and we'll see you tomorrow. Update Friday. Don't forget. Come on, tell us what you're going to do. Tell me what you want to share with us so that we can get you on the show. Oops.
Before me, they taught me to fight for my civil rights, but it's always the same old story. The rich reign supreme while the poor can but dream under Labour or Liberal or Tory. And I say, bugger the bankers and politicians, bugger the bureaucrats too, bugger the buggers who make up the rules. And if you're one of them, bugger you. And if you're one of them, bugger
The system is bent and the money's all spent. We're badgered from every direction. The workers get taxed while the wealthy relax.
with nary a moment's reflection. Where there's brass, there's muck, and they don't give an arse, 'cause we're programmed against insurrection. And I say, give up the struggle for justice. But I've done my time on the protesters' line, and these days I show my dissent